Professor Dernauer, can I ask you, from your perspective, your broad comparative perspective, as someone who knows a lot about not only Japanese law, but also German and European law, what do you find to be the most interesting features of Japanese consumer law and practice?
Well, I'm mainly working consumer contract regulation, and there I find it very interesting that the formation of contracts in Japan is regulated by many, many different laws from many different perspectives: public law, private law, everything is intermingled. It's a big mix of regulation, which is on one hand interesting to see and to see how the structure is, how the whole structure has formed, and how it works in practice. On the other hand, I always am very much in doubt whether this is not a little bit too much, kind of over-regulation, which is black letter law then, but in practice it doesn't really matter, and it's just for the consumers and their advisors, their legal counsel. It's sometimes just too complicated to find the applicable norms, applicable provisions, and also to see how these provisions are, they work with each other. That's sometimes quite difficult to see.
Where you find the major foreign influences, if any, coming from in this field of Japanese consumer law, and also whether you're aware of any impact that Japanese consumer law is having in countries outside Japan.
There are a couple of items where foreign influence is very important. One is, I think, the Japanese, these various study groups and meetings and conferences, they are very much looking on the regulation of unfair contract terms in Europe, for instance. First, it was then implemented into the Consumer Contract Act. It was maybe the basis for that was maybe the Consumer Contract Terms Regulation, not regulation, directive of the European Union. And with the recent reform of the law of obligations, finally, after many years of, many years, scholars were waiting that that finally there's a general instrument in the civil code which to control unfair terms in general business terms, general business terms, because before that there was only this instrument for consumer contracts. Now you have a special instrument to also regulate, to control unfair contract terms in all kinds of contracts. That was mainly influenced from Europe, I think, various, especially Germany, so Japanese scholars were looking at this German approach to control unfair contract terms in general for over 30 years, and they were not able to influence the Japanese lawmakers sufficiently so that they would follow this example.
That is an interesting example. So in the Consumer Contracts Act of 2000, although there is a general regulation or voiding of unfair terms, which is inspired by the 1993 EU directive, the EU directive is limited to standard form consumer contracts, whereas in Japan it's any consumer contract. But as you say, within the EU, Germany has a long tradition dating back to the 70s of a regulation of standard form contracting of any type, irrespective of whether or not it's a business to consumer or business to business contract. And what you would say has been the biggest change in Japanese consumer law that you've seen in the several decades you've been researching and teaching in this field, or if you don't think there has been a big change, which is the area where you expected a change, but it hasn't yet come?
Japanese law is constantly changing a little bit. It's always under construction, so to speak. I think one of the main points where consumer law changed was around in the 90s, and then starting as 2000 with the introduction of the Consumer Contract Act and the and some other laws in this regard. When before Japanese law was Japanese consumer protection was always a matter of public law, of control by agencies, by public, by governmental institutions. Whereas starting in the 1990s, private law instruments have gradually increased. It was kind of a re-regulation of consumer matters. It was not a deregulation. And that is kind of very surprising outcome, because when in Japan it was considered to introduce more private law instruments, it was considered to be a form of deregulation. Well, it was at the time. But nobody thought about whether the agencies and the ministries in control of certain businesses on the basis of administrative law and penal law as an annex to that were following suit and abolishing their instruments of control. And they didn't, of course. I mean, private law instruments are mainly, I would say, discussed in different circles of different people are involved, different ministries are involved, and so nobody who was in charge of the administrative law control instruments was really engaged in this process, and nobody cared about what's happening there. So many instruments, many private law instruments, for instance, for controlling the formation of contracts for consumer protection, like information duties, and so they were added to the whole field of consumer law, but none of the former instruments of control, this administrative law scheme, was not altered at all. So it stayed. So we have now different layers which just added up, they piled up, and that's a kind of surprising result. Well, of course, from perspective today, this era of deregulation maybe has already come to an end for quite a while. For various reasons, nobody's really speaking of that anymore. Many scandals, which have been not only in Japan, also in the United States and Europe, and so maybe nobody now cares about that very much, but at the time it was one of the arguments to enforce or to increase to produce more private law instruments so that the consumer can deal with problems himself when they arise, and go to courts, use the courts, or use ADR proceedings in various forms based on civil law or private law rights and guarantees. Well, in the end, well, there was just putting a new layer on the whole existing structure, on the whole existing legal protection mechanisms, consumer protection mechanisms, and now you have got you have got a mixture of all this, which is sometimes too much, and also the interaction between private law and and public law is not perfectly in Japanese law. That's also because those ministries which, for instance, now were in charge, I mean, the Ministry of Justice were in charge of the reform of the civil code, of the law of obligations, is not the same ministry or same groups in the ministry which are in charge of the administrative law control, business law control, and so there's nobody who would harmonize these two approaches, these two mechanisms to protect consumers. So, as one example, we have got many provisions, many laws which provide that certain businesses, certain entrepreneurs have to inform the consumer about a lot of things, yeah, mostly in written form, but also sometimes orally, sometimes not specified. And if there is such a violation of such a provision, which usually gives the ministry in charge an opportunity to react by administrative law measures, for instance. But what does this violation mean in regard of specific contract? Yeah, when the violation, when the provision itself, for instance, provided that a certain business had to provide information to the consumer before entering into the contract, at the stage of entering into the contract. So is the contract then void? Is it avoidable? Is it cancelled? Can you cancel it? Usually not, because sometimes there are such special private law instruments added to these laws, so that, for instance, many consumer laws have, by their nature, they are public law and private law in combination, but that's just an exception. That's not the rule. That's just for some of these laws, the nature changed by introducing various forms of regulating contracts. But for the rest of the contracts, the contract is not directly influenced by any violation of such public law provisions, and that's not a good thing. Yeah, and also in legal academia, legal scholars are discussing this issue, not particularly related to consumer law, but in general, how does a public law, the violation of a public law provision, what effect does it have in private law? They're discussing it now for 40 years or so, or 50 years, and there's not much case law on that. Only a few cases where the courts explicitly dealt with this problem.
Thank you, Professor Dernauer. That's a very interesting point that reinforces your original observation that Japanese consumer law is actually quite complex for even legal professionals sometimes to gather and understand, because it has this multi-layered effect of public law regulation on the one hand, and then private law effects. And the last point I'd like to just add from my perspective, again looking at the more on the product safety side, is that the biggest change probably in more recent years is about a decade ago, when Japan established an independent consumer affairs agency, rather than having some of that function within the Cabinet Office, or previously the Prime Minister's Office, which obviously has a broad mandate and has to, look at things like economic planning more generally, and combined with the consumer protection aspects of some other ministries, like the Ministry of now External Trade and Industry, which might have competing interests, obviously, in promoting business activity rather than consumer protection. So the last question I want to ask before we end is whether you have noticed any significant impact from the COVID-19 pandemic in terms of consumer issues that have arisen and have, you know, caused a lot of discussion, maybe even some particular law reforms or regulatory action taken because they've caused a lot of problems in the consumer marketplace?
Well, no, actually, to make it short, no, I'm not aware of any such big issues. Of course, it's not yet. I mean, we're just in the middle of the pandemic. Maybe something will turn up shortly. I don't know. But as you know, I mean, the approach to regulate pandemic-related issues. I mean, with regard to business as well as regard to consumer-related matters. Was very, I say, mild. Yeah, it was more suggestion what you should do or what you shouldn't do, and nobody was really forced to shut down its business. So if you're not forced to shut down the business, then it's on your own to decide whether you do it or not, and then you cannot bring any claim in this regard. I mean, I was in Melbourne last year, so I have many contacts with people living in Melbourne, for instance. It was a totally different situation when the pandemic started. I mean, the regulation was very, very strict. And here in Japan, I returned in March, came here and was looking around. Well, there's a pandemic going around, but the shops are closing a little bit earlier than usual. But apart from that, you wear your mask, and there are no further really restrictive measures in place.
That's very interesting because in Australia, we've had quite a lot of complaints and follow-up through consumer organisations and consumer regulators, for example, over the refunds for cancellation of travel. Initially, airlines and travel companies were not giving refunds. They would at most give a voucher for future purchases and so on, sometimes relying on terms in the contract agreed to by consumers, but typically never read, like most consumer contracts. But the regulators and so on raised the possibility of those being an unfair term, and therefore, you know, a reversion to the general law of contract, which allows for contracts to be terminated for frustration if, you know, you don't get the service or you can't travel because of an unexpected supervening event like a global pandemic. So, well, thank you, Professor Dernauer, taking time at a busy time at the end of this pandemic year of 2020 to talk about your specialist field of consumer law, particularly from a comparative perspective. And we hope to see you in person again as an angel visitor again to Australia in future years, or otherwise involved in our activities of the Australian Network for Japanese Law. Thank you.
Thank you very much for interviewing me.